the idea of working on any of these investigations. He did bring up the idea of me working on another case before that. So that happened, and I ultimately declined to work on that case, and then the other conversations happened after that. So I just wanted to put that on the record.
Okay.
Another case not related to?
Not related, correct.
At that point, were you ready to seek a new opportunity? You know, you had been in The Hague for some time. Were you looking for an opportunity to come back to the United States?
I really loved my work in The Hague, but for family reasons, if the right opportunity happened, I wasn't desperate to come back, but if the right opportunity happened, I was willing to do that. That's one of the reasons I spoke to Mr. Miller.
Okay. At the end of the last round, I asked you whether you had any communications with the Michigan Attorney General, Dan Nessel, and you said you did not.
Yeah, I don't recall any.
And to the best of your knowledge, you don't believe anyone on your staff was having communications with the Michigan Attorney General's office?
Well, what I thought I said was, I don't recall that. It may be that we got inquiries from them. That may be possible, and it may be we responded to those inquiries. I don't recall sharing information with them or getting information from them.
But to the extent there's an allegation made that your office was coordinating with state attorney general's offices to have prosecutions go on, and different prosecutions happen in the states, would you say that did not happen and that would be false if somebody made that allegation?
We were not trying to coordinate prosecutions with other offices, no.
Okay, and you were not trying to encourage prosecutions at the state level?
No, I don't recall anything like that.
Okay. And so the same can be said with the Attorney General for the state of Wisconsin, Josh Call. Did you have any communications with him?
I've never spoken to Josh Call.
Okay.
Again, we may have got inquiries from their office, and it could be by phone or by a letter. I can't say that didn't happen.
Okay. And to the best of your knowledge, your staff did not have a regular set of communications with the Wisconsin Attorney General's office?
I don't know about regular. If there were requests, or if there were people who reached out to us, we may have spoken to them back. I don't recall with much specificity anything about that. We definitely were not trying to coordinate a case with them.
Okay. And can the same be said for the Attorney General for Nevada, Aaron Ford?
I don't even know that name, Aaron Ford. Again, I just want to be clear. This subject you're asking me about interactions with State Attorney General's office, this was not a focus of mine. As the special counsel, I was focused on our cases, our investigations, and our case and what we were doing in court in our investigations. This is the sort of thing that other people in my office would have dealt with, and so I'm probably not your best witness in terms of the level of interaction or witnesses, but I don't recall sharing evidence with those offices.
But if your office did have meaningful coordination with the state attorney generals, you probably would know about it. Is that fair?
Meaningful coordination, I don't know what that term means, but like I said, I'm trying to be as specific as I can, limited by my memory. I don't recall us sharing information or sharing our files with attorney general's offices. I don't recall them giving us their files, things of that nature. Beyond that, the number of times an office may have reached out to us and how we replied to that, I really don't have a recollection of those sort of subjects. I'm trying to be as clear as I can.
Fair enough. How about with outside Democratic lawyers such as Norm Eisen? Did you have any communications with Norm Eisen?
No.
During the pendency of your investigation? Do you know if anyone on your staff did?
I don't know of anybody having such a communication, no.
Okay. And how about with Mark Elias? He is a election law attorney for Democrats.
No, I've never met him.
Okay. And to the best of your knowledge, your staff wasn't communicating with Mr. Elias?
To the best of my knowledge, yes.
Same question. A gentlelady by the name of Mary McCord.
Mary McCord, I do know. I didn't know her well, but I knew her from when I had brief interactions with her. She was, I think, at the U.S. Attorney's Office in Washington, D.C., while I was the Chief of Public Integrity. I don't recall having any interactions with her during the pendency of the investigations. At the conclusion of the investigations, one of my lawyers went to work at her project at Georgetown, and I did speak to her about that.
Okay, and what is her project at Georgetown?
It's some sort of clinic at Georgetown University. As I sit here right now, I don't know the specifics.
But you didn't have any discussions with her about the facts of the case?
No, my recollection, that may have been the first time her and I had ever actually had a conversation, her and I talking to each other.
Okay.
But we definitely didn't talk about the case while it was being prosecuted and investigated.
We've discussed, both sides, I think, have, raised the fact that President Trump was, he's being prosecuted by a lot of different tribunals at the same time. I mean, he had the District Attorney of New York, he had a civil case with the Attorney General for the state of New York. He had two federal cases. And, I had asked you about how you managed the calendar and the calendar with President Trump. I mean, there were times when he was required to be in New York 3 or 4 days of the week, and then he had to be in Florida for, I think we discussed at the end of our last round, for a pretrial motion hearing. And it just seems that at every instance when President Trump and his lawyers requested a little bit of a delay because of the cases they're defending, your office was not willing to indulge that request.
It is correct that we were not willing to indulge delays that we thought were inappropriate. I will add, and this is in the litigation, there were numerous instances where judges chided counsel for President Trump for trying to delay things. I'm thinking, as I'm saying it now, I'm thinking specifically of the executive privilege litigation that we had. This is referenced in our final report of him attempting to delay things. And so we agreed to dates that we thought were appropriate. All of that, as far as I'm concerned, was very public and transparent. What the dates were and the arguments to the judges about those dates were clear, and I thought they were fair and reasonable.
Even against the backdrop that he was being tried by the District Attorney of New York, and even against the backdrop that he was involved in a high stakes proceeding with the New York Attorney General?
Yes.
For example, at the time you proposed the DC schedule, you were also aware that Georgia prosecutors had proposed motions hearings, essentially during the same time period. If President Trump's lawyers had requested a delay for that, would you have indulged that? Or did you indulge that if they did ask for it?
I don't recall if they asked for a delay, and to consider whether I would indulge that, I would have to be back in that moment and look at the facts as they existed at that time. I don't recall that as I sit here now.
President Trump complained that he was treated unfairly with respect to access to the classified information that was at the heart of the Florida case, that he wasn't able to review the materials at the heart of the trial because of restrictions imposed by the government that required him to only review the materials, on your turf. Is that something that your office did intentionally?
I think this may be one of those subjects that may be in the final report in Florida, so I don't think I can get into that.
Okay.
I'm not sure it is, but it may be, and I just want to exercise
Okay.
caution.
So I have some questions along this line. If that's going to be your answer, I understand that. So I'll just,
If you can point to a public filing where this has been discussed, I'm happy to comment on the subject in the public filing, because I think my understanding is it's pretty clear that I'm allowed to discuss public filings, and so if there is a public filing you're aware of, I'm happy
yeah,
to address that to the extent I can recall it.
okay.
I want to answer your questions as much as I can, I just don't want to run afoul
Right.
of this injunction.
The heart of the question is, he had a skiff at Mar-a-Lago that was decommissioned when he was no longer president, but during the pendency of the case, it would have been relatively easy for him to get that skiff at Mar-a-Lago back up and running. And, he indicates that your office blocked that and, required him to only look at the classified documents, only talk with his attorneys about the content of the classified documents in a DOJ suit.
So-
And that puts us, a remarkable burden on him, especially given all the other cases that he was defending.
Okay, so if there is a public filing about this, I am happy to discuss this with you. I just want to make sure that there's a public filing, so I'm not running afoul of anything in the injunction.
See if we can get it quickly.
Sure,
If not,
of course.
maybe we'll move on.
Yeah, and then we could come back.
Come back to it. After the immunity determination at the Supreme Court was decided in July of 2024, you filed a remarkably long brief in September of 2024. I think it was like 165 pages, and the brief was very, very unusual in terms of length and content. What can you tell us about your decision to proceed with that type of meaty brief? It's almost as if you were writing your, special counsel report in that brief.
Sure. So, as an initial matter, I think the vast amount of the factual material in that brief was not new. It was just put in there to address the issues at hand. The context of this is we received this immunity decision. The immunity decision affected not only the indictment, it affected the evidence we could use at trial. And so for there to be a litigation of this, the defense would have to know the evidence at trial. We would have to say, this is the indictment, and here's the other evidence that we're going to use at trial, in summary at least. We all understood, at least certainly I did, that this case was going to go up to the Supreme Court at least one more time for an interpretation of a lot of the questions that the Supreme Court left open, which we addressed in the final report. Our goal was to have that be one time, and to have the evidence and the indictment get rulings from the court. If the defense didn't like them, they would get to appeal them. That would go up to the Supreme Court. We get a final understanding, and then we'd be back before the court to try the case. And so to do that in one trip as opposed to multiple trips, and multiple trips could mean years in terms of how long it would take to try a case, that required us to go first to, in essence, put this there. And I said this earlier in the day to you, one of the challenges in this case is we had, in my view, a very strong case with a lot of evidence, and trying to condense that into a brief at that stage where we were not going to be precluded from offering things that we thought were important, that could possibly be relevant to any of the immunity issues, but also have a fulsome brief. That's what we filed. It was my judgment that that was what was necessary, and I think, again, if you look at that brief, the vast majority of factual information in that brief had been in the public, or something close to it in the past.
Mm-hmm.
Required you to go first, or you chose to go first? Because the normal case is my understanding, you file a superseding indictment, defense is gonna make some motion, they're gonna have some reaction to that, and then you would do a brief. But you flipped it.
Well, because in this particular case, we had the opinion that caused us to supersede the indictment. The court said not only what's in the indictment, but the evidence too. And there had never been a point at that point where we had put on the table, here's all the evidence that might be related to immunity. And so we needed to do that, otherwise the defense couldn't respond to it. What would have happened would be, we file a brief of our trial evidence, of our indictment, they say no or not, then that goes all the way up to the Supreme Court, then we come back from the Supreme Court, now we're gonna do a second year.
Doesn't change the question, Mr. Smith.
I'm sorry.
Was it required, or did you choose it?
I believe that was the most appropriate way to go forward, yes.
It's not my question. Was it required, or did you choose to go that route?
Oh, I chose it.
Okay.
But I'm sorry that I wanted to explain the reasons why I chose it.
And did you have to file a motion with the judge for leave to offer that type of filing?
We had a status conference with the judge shortly after the return of the superseding indictment, and we proposed, my choice, that sequence, but we left it to the judge to decide the timing of that sequence, of when our brief would be due.
And what was the timing of that sequence, to the extent you can recall?